maybe forward to the U.S. Marshals, send it to Bowling Green, Kentucky, that the practice of accumulating this mail in a cubby, in a pigeonhole, in a box, all in the same room, in the mail room. That law was clearly established in 2007 that put Defendant Johnson on notice that what he was doing was wrong. And even
your adversary brings up the point, and it's not a point that isn't worth thinking about, and that is, the cases about prison officials making a judgment, you don't get this kind of mail. It's like improper categories of mail, so we're withholding it forever, right? Or the cases where there's some other security-related delay, or we've got some cases. So the things going on in those cases are a little bit different than here, where if somebody's on a transfer status and you as the prison receiving the mail aren't exactly sure the transfer plan, like what day they're coming back, there's always this risk that if you forward the mail, it might get lost somewhere because the prisoner's on their way back. And if you just held it, then there wouldn't have been a problem. You could have just given it to them and it wouldn't have been lost or something. So, I take that is a factual distinction. So why doesn't that matter in our clearly established analysis here?
It shouldn't matter in clearly established, Your Honor, because there's case law that's dealing with this exact same issue where in Simpkins v. Bruce, a prisoner was transferred for a year and was out to court for a year. And the 10th Circuit not only found that the mailroom supervisor's actions of withholding that mail were unconstitutional, that mailroom supervisor was in fact not entitled to qualified immunity as well.
In the facts of that case, I remember that case, but I don't remember all of the details. Did the prison that was receiving the mail have an understanding of the time period for that, like it was going to last a year, or did they not? Like here, I don't think there's anything that tells me that this prison knew how long he was going to be gone serving as a witness in some other case.
Yes, Your Honor, so it's unclear from the record, to be honest with you, in the 10th Circuit case. I will say that they similarly did not have a forwarding address, that the defendant in her deposition noted that if she had the forwarding address, she of course would have immediately sent it on, which seems to suggest that there's a recognition that at least within the 10th Circuit, when you're out to court, you should forward that mail.
Would you agree with me that there is a line, right? Like if somebody's gone, as your adversary pointed out, for a day or a half a day or whatever, that we wouldn't want to forward mail in that scenario because it's just going to get lost or it's going to get more delayed for sure. So isn't there some sort of time frame there? Like, is a week too long? Is a day too long? Is a month too long? And obviously we're at the outset. We've got a long period of time. We're probably not close to that line, but because there probably is a line somewhere, in terms of the clearly established analysis, do we need a case that tells us where that line is?
Not for this particular situation, because the Title 15 regulations in 2007 said must be forwarded with immediately. They changed in 2008 during this time period in June 2008 to say that the mail must be forwarded within a week, within 7 days, which seems to suggest, and now I would like to point out, Your Honors, that Title 15 regulations in particular have, authority, and they note seminal cases like Precedent v. Martinez, Lewis v. Casey, Thornboat v. Abbott, for these propositions of the necessity of forwarding mail. Because what happened to Mr. Penton is that he lost his ability to timely appeal his habeas petition. He lost his ability to know that his father was dying and lost the ability to speak to his family before they died. Even if, Your Honor, as you submit, that out to court, 7 months, November 8th, 2007, June 19th, 2008. Those 40 days of withholding, it's clearly established that Johnson had to give Mr. Penton the mail once he returned. And the fact that he didn't, the fact that Mr. Penton receives his mail 4 days after his father died caused him irreparable First Amendment violations. And that's why this case is going to trial on Monday, because there are these facts of dispute. Was it the forwarding address? Was it the practice of holding the mail, as the magistrate court notes in his findings and recommendations as adopted by the district court? Judge Wallace noted in the PG&E para hearing that it's up to the district courts to manage their dockets. They're very busy. I know, given some of your backgrounds, you know how busy district courts are, and in particular, the Eastern District is particularly busy. Yet that court decided that this case deserved to go to trial by certifying this appeal as frivolous. And it is for these exact same reasons that we would submit that this interlocutory appeal should be dismissed. I will, pending any other questions, I'll yield the rest of my time.
Judge Wallace, do you have anything further?
I don't. Thank you.
Boggs? No. Nope. Thank you, counsel.
Thank you, Your Honors.
All right, Ms. Cahill, you have 2.5 minutes.
Thank you. I don't have much time, but I'll just touch on a couple points that were brought up by my colleague. They're asserting that that it should be a disputed fact that the mailroom didn't know where he was. That's just argument. There is no evidence to dispute that. And at this stage of the case, that's not sufficient. There has to be some sort of contradictory evidence in order to actually dispute that fact. There wasn't a deposition of the litigation coordinator or anybody else in the mailroom that can actually contradict what Johnson said in terms of what the computer system provides. So that's not a fair characterization. I believe there was testimony that from counsel that the expert who was not an employee at any time of this particular institution, I mean, he has no basis to offer an opinion or assert a fact that CSP Sachs mailroom had this information. So for those reasons, I don't think that that's a fair characterization of the evidence in this case.
Did you make a challenge to that expert as not being properly presented?
Did I make a challenge in what context?
Did you make a motion to say that that person isn't actually an expert in the field that he or she purports to be?
I have a pending motion in limine on that issue for trial coming up. I don't recall. I was trying to verify in the record if plaintiff cited to that deposition testimony for purposes of trying to dispute that fact. I don't see that they did. And I'm looking at the record. It's 2 ER 221 and 222 with respect to our motion for summary judgment. So
let me ask you real quick aren't you in a sense putting them in the position of trying to prove a negative? Can't you say that prisons generally know where their prisoners are or know where they went? He didn't just wander out the front door. If he was an escaped prisoner, I could understand that argument. But that the statement just "I didn't know" doesn't mean that you can't say that from the circumstances it's a disputed fact as to whether he has access in the prison system to where he went. Because you're just saying he said "I don't know," and you got to prove what he knew.
Well, I'm not suggesting that they have to prove what he knew, but I am arguing that they have to have some sort of evidence that the system or that the mailroom could have found that in their system. So either someone else that worked in the mailroom or someone that was familiar with the computer system and what it displayed, something like that, other than just argument that
prisons generally know where their prisoners are.
Well, yeah, frankly, and in this case in particular, he was transferred by the U.S. Marshals, who don't typically share the transit of their inmates. This inmate in particular it took him at least 3 weeks, if not longer, to even get to his destination. So no one told the mailroom at the end of his transport that, hey, he's finally here at the the final destination in Kentucky. So and their expert did concede that during a lengthy transport, it wouldn't be reasonable to forward the mail because he'd be bouncing around, and we run into the situation that Your Honor hit on earlier.
All right, counsel, you've run over time. Do we have any further questions?
No.
Judge Wallace?
No, thank you.
All right. Thank you, counsel, for your arguments in this case. The matter of Penton versus Johnson is submitted.